Hey everyone, welcome back. This is Will Dungy, and you're here for another tax court analysis. Today I'm going to be talking about Westerhold versus Brick Township and Westerhold versus Toms River Township. This is an unpublished decision by Judge Mark Cimino. Now, these are two separate appeals, but for purposes of Judge Cimino's opinion, he consolidated it into one written memo. So this is a case type that involves a property tax assessment, and it's a third-party property tax appeal brought by the Westerholds against the Normandy Beach Association. So uh, the Westerholds used to own beachfront property in Brick Township, and they filed a third-party appeal against the Normandy Beach Association and the assessment of their property. The Normandy Beach Association is the owner of a dune system that was built between the Westerholds property and the ocean front. The case raises questions about property valuation and access rights and how government actions affect property assessments. This case originates back to Superstorm Sandy, which devastated New Jersey. Prior to Superstorm Sandy, the Westerholds could walk directly onto the beach from their property. After the storm, the federal government and the New Jersey Department of Environmental Protection constructed a dune system in between the Westerholds' home and the Atlantic Ocean. But the Westerholds built a footpath across the dunes to get access to the ocean. At some point between the construction of the dunes and the Westerhold's creation of the footpath, the dunes became titled under the Normandy Beach Association, which objected to the footpath and insisted that the Westerholds use a nearby stub street for access to the ocean. This resulted in several complaints being filed in the Superior Court and the Municipal Court, most of which are not relevant to this opinion. So back to the tax case here. The Westerhold's third-party tax appeal is not quote unquote legal anymore. It was actually repealed pursuant to Assembly Bill number 1135, which was enacted in February of 2021. This case was initiated in 2020, so they had a grounds to appeal another person's taxes, which I'm not certain of it, but I think this case might have had something to do with why this law was repealed. So one note, you definitely can't do this anymore. You might not like your neighbors, but you cannot appeal their taxes to make sure that their taxes go up. The trial for this matter was originally scheduled for the December 8th, but this opinion was issued December 5th. And it was issued because the parties produced appraisal reports that were widely different on the subject properties. So the Normandy Beach Association had a bayfront clubhouse in Brick Township, and they also had oceanfront properties that were in Brick Township and Toms River. Obviously, the Westerholds claimed these properties were underassessed. The Normandy Beach Association valued its bayfront property at $100, and the Westerholds placed a value of the bayfront property at $10 million. The Normandy Beach Association valued its oceanfront property at $2,800, and the Westerholds valued the oceanfront property at $28 million. The clubhouse is a nearly 1 acre parcel of land that has 300 feet of bayfront. The bayfront property was assessed at $800,000. The Normandy Beach Association claims that the property cannot be sold unless 30% of the property owners and 5/7 of the governing board approves the sale. Now, the Westerholds argue that the parcel can be subdivided into 7 residential bayfront lots, each with a value of over $1.4 million and a total valuation of close to $10 million. Now, Normandy Beach Association is relying that these restrictions on the sale can lower the assessed value of the property. Now, restrictions on sale do lower market value of the property, and that can be seen when selling in a fair market value arena, or whether you're trying to value property for estate tax or any other type of tax purposes. But for this instance, this case resolves around property tax assessments. And the overall gist in New Jersey is that can a court require private transactions like the association's rules here and let that affect the assessed value? Past cases suggest that such contractual limitations do not lower assessed values. But everyone is allowed to litigate and come in and prove their argument as to why their argument should succeed. The oceanfront property that's also being appealed stretches roughly 3/10 of a mile, and it's parallel to the ocean in two townships, Brick and Toms River. The baseline legal question here is whether the court can reduce the assessed value for the Department of Environmental Protection's easement to construct dunes. So in this situation, the underlying question must be whether the easement is a conservation easement that benefits the public, which that easement can result in a reduced assessment value. But the definition of a conservation easement must meet what is actually being used, how the land is actually being used by Normandy Beach Association. Also, in the court's analysis, the court determined that the vertical depth of the oceanfront property is unclear. And obviously, if you didn't know, the size of a property also affects the assessed value. And landowners that have a boundary on the sea are obliged to accept the alteration of their land by the changes to the shoreline. And this is normally done by use of the mean high water mark, which is the boundary line that divides private ownership and the public ownership of tidally flowed lands. Another question here is whether the Normandy Beach Association can even charge for beach access, and whether this affects the income-producing nature of the property. And again, if you're not familiar with property tax appeals or valuing land, income-producing property the amount of income that it has can reduce the assessment or increase the assessment depending on if it's a very profitable piece of property. So the question here is the property like a toll bridge or an amusement park or something else? And if the property is primarily dunes, can the association collect fees at all? This reflects the long-standing opinion in New Jersey that no fees can be charged solely for access to or use of tidal waterways and their shores. So Normandy Beach Association finds themselves in a little bit of a sticky situation here. So ultimately, the court entered an order for the parties that said, hey, you guys need to brief these legal issues. I just set forth all of the issues here, and you need to come back to me and saying why the law is on your side. And so I'm not sure if a new hearing date has been set forth yet, but this case does show the complex property how complex property valuation can be when government actions, natural disasters, and private association interests all intersect. I mean, as you can see, both sides' appraisals differ widely, and this is very unusual in the tax court. I'll be keeping my eye on this case, and I'll post follow-ups with further analysis as the court issues its decision. If you want to dive deeper into similar tax cases, check out my other videos on my channel, and I will be posting new material because I understand that there are several new opinions to be coming out this year. Hope you like this. Have a great day.